Thank you, Mr. Shima. We'll call 128-007 in the matter of Shawn Stewart. Ms. Butler?
Good morning, and may it please the court. Kate Duncan Butler appears this morning on behalf of the Office of the Disciplinary Administrator. Madam Chief Justice, I would request 3 minutes for rebuttal.
3 minutes is granted.
Thank you. This is an original proceeding in attorney discipline involving the respondent, Shawn Stewart, who has been licensed to practice law in the state of Kansas since 2002. This matter comes before the court after an evidentiary hearing held on May 1st, 2024. Prior to the hearing, the parties stipulated to the operative facts underlying the case, as well as Mr. Stewart's violation of KRPC 8.4 subsection C, which is misconduct involving fraud, deceit, dishonesty, or misrepresentation. As such, the parties focused on evidence concerning the appropriate discipline at the hearing. The Office of the Disciplinary Administrator's theory of the case was that Mr. Stewart repeatedly violated KRPC 8.4C by providing information he knew to be false to the Kansas Department of Labor to apply for and maintain certain unemployment benefits during the COVID-19 pandemic. In the final hearing report, however, the hearing panel found that Mr. Stewart had only provided false information and therefore had only violated the rule a single time, and that act, which involved representations of his income, only constituted negligent misrepresentation and not intentional or knowing dishonesty, as our office had alleged. The hearing panel recommended a published censure. The Office of the Disciplinary Administrator filed exceptions to the final hearing report on August 23rd, 2024, objecting to many of the hearing panel's findings of fact regarding Mr. Stewart's conduct, his mental state, and the aggravating circumstances appropriate in this case. To summarize the facts that remain undisputed on appeal before I get into the specificities, of our argument, Mr. Stewart was a solo practitioner at the time involving this case, and he operated a law firm out of his home. His primary client had been a business client that he had done transactional work for and then later went on to represent in litigation. In 2019, the work in the federal litigation had largely turned to collecting the judgment from that litigation, and he and his client jointly converted their representation to a contingency fee matter. Mr. Stewart testified at the hearing that they did not really anticipate collecting. I believe he called it a futile endeavor, and stated that sort of around the time the COVID-19 pandemic arrived, work for that case had slowed down. In March 2020, as we are all well aware, the COVID-19 pandemic shut down many businesses and government entities. At that time, Mr. Stewart applied for unemployment. It was traditional unemployment, and because he was self-employed and did not have reportable wages, his application was denied. Later in May 2020, the federal government implemented new legislation that allowed for self-employed people to receive unemployment under a program called Pandemic Unemployment Assistance, or PUA. Mr. Stewart applied for that program shortly after it became available, stating on his application that he had become unemployed on February 29th, 2020. As part of that initial application, he had to fill out an income verification sheet that asked for his quarterly net income from 2019. Mr. Stewart represented that he made $30,000 net income each quarter, or a total net income of $120,000 in 2019. That was not accurate. He had not completed his 2019 taxes at the time, and while the $120,000 was close to, actually slightly less than, his gross income from 2019, it was not accurate to his net income. Nevertheless, the Department of Labor approved Mr. Stewart, and he began receiving PUA unemployment benefits. To receive benefits under this program, each week, Mr. Stewart had to fill out a weekly claim form in which he had to provide the Department of Labor certain information. It was a sequence of check boxes that had to be filled out, many of which are in the record at Exhibit 11. Those check boxes, among other things, asked whether the claimant had worked or received income in traditional employment, or had worked in or received compensation for self-employment during the given week. With the exception of 1 week, Mr. Stewart indicated each week that he had neither worked nor received compensation in self-employment during that benefit week. He continued to fill out the forms throughout the benefit period, including during the period in which he had stopped receiving benefits because his benefits had been suspended due to the Department of Labor investigating him. The Department of Labor, at the end of the benefit period, after investigating Mr. Stewart's claims, found that he had committed fraud under their standards by either supplying false information, having another supply false information, or not submitting information to the department when asked. Mr. Stewart appealed this initial finding, but ultimately did not appear. The reason he did not appear was at that time he had been in contact with the Department of Labor trying to work out how to repay the benefits he had received. Nevertheless, the Department of Labor upheld the finding on a default on appeal because he did not appear and submitted a complaint regarding his conduct to our office. At the heart of the appeal in this case.
Can I stop you right there? So there was never any evidence presented to the KDOL. Those were default judgments, right?
Correct. Mr. Stewart's conduct in filling out the forms, both the application for unemployment and the weekly benefit forms, are really at the heart of our issues on appeal. The hearing panel rejected 3 different instances that our office had alleged was dishonest. A representation he made about his business client on his initial employment application, and then his conduct in stating that he did not work in weeks he did, and stating that he did not receive compensation in weeks that he did. And so I would like to address each of those in turn. The initial on his initial unemployment application, Mr. Stewart filled out a blank that asked why is he unemployed? And he said, because the COVID-19 pandemic had shut his only client down. The hearing panel reasoned that because the client had been closed down, and there's testimony in the record that Mr. Stewart learned his client had been closed down because of COVID-19, Mr. Stewart was not getting any work from that client. Ergo, that was the reason he was unemployed. First, it's important to note that the record does not reflect that Mr. Stewart was anticipating other work from that client apart from that matter that had been converted to contingency fee litigation. It is also not clear when, in relation to the pandemic, Mr. Stewart learned about the shutdown of his client. Nevertheless, what the record does reflect is that at the time Mr. Stewart made that representation, he had converted that representation of his client to a contingency fee matter. And by that, he was no longer expecting to receive regular compensation for that client. He was unemployed under that client, not because of COVID, but because he was doing contingency fee work and was not receiving payment for that. And in fact, he had testified that at the time he applied, nothing had happened on that case for a number of months.
Is the problem that there's no causation? Is that the issue, that the operations weren't closed by COVID, or that he represented that the operations had shut down? Because that sounds like not an inaccurate.
It was not inaccurate in a vacuum to say COVID shut my client. That was accurate. But the shutdown was not the reason he was unemployed. He was still working for that client and still involved in that client. He just wasn't receiving additional work from that client or additional paid work because it was this contingency fee agreement. There is not evidence to support the hearing panel's reasoning that, well, the shutdown foreclosed all chance of him getting regular paid work from the client, because what he was doing was work that would only be paid out if he collected the judgment.
Did the employer, or did his client sell the business?
There is something in the record. I don't have a picture perfect memory of it, Justice Standridge, about the business had been sold, but he was still involved in the litigation.
So is there anything about whether he was providing any kind of services to the new client?
I do not recall that there is evidence to that. Obviously, if the record reflects differently than what I'm saying, I don't recall there being anything.
Okay, and then did the new client shut down because of COVID?
I think it is that business that had been his primary client was the one that shut down. I think that part is not fully fleshed out, to be honest with you. And so I don't know if the exact relation. It is just that the client he was doing the regular work for was shut down for COVID, but the reason he was not doing regular paid work was because of the contingency fee matter.
Given the ambiguities that you've just conceded in the last three questions, how is there clear and convincing evidence that he lied?
There's clear and convincing evidence because there is nothing in the record to support the only evidence in the record about the relationship with the client and what kind of work he was doing with the client at the time he applied for unemployment is the undisputed and stipulated evidence that he was working only on a contingency fee matter for that client.
But he.
And the finding that, I lost my word, I apologize. The finding that he was expecting more work is not supported by the record. And so the hearing panel essentially disregarded the existing stipulated evidence with an unsupported fact.
But you just said that the record is unclear about whether the new client would have hired him.
My recollection of the stipulation is that that client, and I'm going to review the stipulation in this moment, is that client, and I don't know the exact details of the ownership, that client was the one that the contingency litigation, it became a contingency fee representation, and that is the client that was shut down by COVID. So I don't know that the issue of who owned the client, it is the same client.
But there is some evidence to support what he said happened, even if it's doesn't fill in all the dots and give all of the context as to what was going on with his client and what may have been ongoing with him.
Correct. But taken, and the state, and again, our office is not saying that the statement that the client was shut down by COVID is inaccurate. It is saying that the reason he was unemployed was that shutdown is the inaccuracy. It in context.
But they can be connected.
They could be connected, yes.
Okay, and I just want to make clear,
Yes.
for this singular isolated incident, you're asking that respondent's law license be indefinitely suspended.
I am about to run out of time and I'm concerned I will go over. May I answer this question?
You may.
Our office is not requesting for that isolated incident of that one statement. No. Our theory of the case and our allegation is that we are asking because of the pattern of dishonesty and the ongoing dishonesty throughout the life of the case. And I have not been able to get into all of the other facts and all of the other allegations within our brief at this time because it is a factually complicated case. And there were a lot of facts contained in the final hearing report that we believe support that he committed multiple instances of dishonesty within this benefit period, and that the final hearing report's facts that they relied on to supplant the stipulation that they acknowledge and that they also find facts consistent with the stipulation are not supported by clear and convincing evidence. Nevertheless, it is the totality of the dishonesty in this case. The initial dishonesty stating that COVID-19 had shut his only client down and that is the reason he is unemployed. But even if this court were to find that clear and convincing evidence does not support that standing alone, his false information about his income, that he grossly overestimated or overrepresented the amount he made in 2019 that then the Department of Labor relied upon to start paying him benefits. And then his representation throughout the life of the case that he was neither working nor receiving compensation in self-employment when the undisputed evidence within the stipulation and within the exhibits demonstrate that he was working on many or receiving compensation on many of those weeks. Not every single one necessarily, but I believe exhibit 30 demonstrates that he worked 38 of the weeks during the benefit period and with one exception said he was not working. And so taken all together and given
Well, he was working for no pay.
the forms do not differentiate between working and receiving income are within the same question, but they do not differentiate between the two when it comes to self-employment. There are also several weeks where he received compensation or actualized compensation, but did not report it as well.
Right, and so, and then there was also a mix-up, which the panel found was, grounded in good faith about, the receipts that, when he estimated, that was receipts into the law firm, but didn't take into account any expenses and what his actual income would be, correct?
Are you referring to on the income form, or are you referring to?
I'm referring
his-
to that he did an estimate of 120,000, and maybe it was close to that, but his income was only 38,000.
Yeah, so there is testimony that my recollection of the transcript is that Mr. Stewart didn't have a full memory of why he chose those numbers. He said he must have looked at his receipts and he, must have, based on that, made that determination that he recognized was no longer accurate. One of the things that our office briefed discussing both intentionality and pattern of misconduct is the fact that Mr. Stewart never, when he did fill out his taxes, attempted to correct that information with the Department of Labor. Eventually, he had to upload his tax returns to the Department of Labor. That happened shortly before the investigation process started with the Department of Labor in 2021. But nevertheless, and he describes that behavior as reckless and just doesn't have a great memory of that. As for to the extent that his sort of estimation and who received the money, because that did also come up at the hearing. And there was a discussion of, well, the money was paid into the law firm and Mr. Stewart was paid out of the money paid into the law firm. Mr. Stewart acknowledged that he would have actualized that money that came into his law firm, that compensation, at a time during the benefit period where it would have needed to be reported, and he didn't do so.
What does actualized mean? I don't understand.
When we discussed it in the hearing, actualized, I believe in our discussion was it would become your money for your purposes. He would have paid himself essentially.
Go ahead.
I have a specific question about restitution.
Yes.
It appears that there's an agreement that he was going to pay $45,000 plus a penalty.
Yes.
And the amount of the restitution, I believe that that the Department of Labor concluded retroactively that appropriate PUA weekly benefit to Mr. Stewart would have been $390 instead of the $488 that he actually received. My question is he paying in restitution the total amount that he received or the difference between what he could have received and what he did receive?
My recollection, and I will be happy to look up the stipulation regarding Mr. Stewart's repayment, because I'm not sure I have the details of that with me at the podium, Justice Wilson. My recollection is because of the finding of the Department of Labor, he is required to pay back all, this is in the original stipulation as well, he is required to pay back all benefits and the penalty, not simply the difference.
Right?
I have a couple questions if the chief
I'm
and the
done.
court will indulge me. Just a practical question. Isn't the problem of this case, doesn't all this arise because the Department of Labor's forms were created in a legal environment where self-employed persons couldn't apply? And then there was and if I'm wrong about this, correct me, but then there was congressional legislation which enabled self-employed people to apply, but he's using the old forms.
My understanding is these are forms made for the PUA program. All of the forms that are in the record say PUA questionnaire, and it has the self-employment question on it. So I cannot.
But, okay, fair enough. Do you know, or is it in the record, whether or not the Department of Labor just essentially copied and pasted the existing forms and then added a self-employment question on?
That is not in the record.
Okay.
I will note also that the forms for the PUA program have questions directly related to COVID as well.
Okay.
So they seem to, if not be related to, directly to self-employment, related to the pandemic and the special kind of assistance that is. I will also just note for the court that the parties jointly stipulated to many of the facts. And so some of those details that would have ordinarily come out regarding exactly how the program worked, the parties accepted that we were not going to
So
discuss that.
one legal question with respect to that. Was the respondent's law firm organized as a pass-through entity?
I apologize, a pass-through entity?
In other words, the income to the law firm passed through to the owner for tax purposes. It was not a corporation, in other words.
I believe it was an LLC.
And as a pass-through entity, maybe you don't know the answer to this question, I'm not sure I do. The income is income to the owner, all of the income. Is it not?
Justice Siegel, I will be honest with you that business associations is not my area of expertise. I don't know the answer to that. The testimony is that the money in the way Mr. Stewart's business ran was that the money came into the law firm, Stewart Law Firm LLC, then expenses
Right.
were removed.
As a legal matter, though, that's all his money. And the only question is how much of it is taxable? Because there are deductions for expenses on a pass-through entity, right?
I will agree with that to the extent I know, yes.
Okay, so I'll leave that behind. And my last question has to do specifically with paragraph 114 of the hearing report, which is where they find one violation of 8.4C.
Mhm.
And they find it on the grounds of negligent misrepresentation.
Yes.
So my question is negligent misrepresentation a thing under 8.4C?
Well, 8.4C recognizes misrepresentation.
Right, so it's a legal question as to what that means. And I guess I'll throw out a hypothetical. If I'm filling out an application for a home loan or whatever, and I round off my income, have I violated the rule?
It is a misrepresentation. So I would say yes, unless.
Is that right? I mean, do our rules require, I mean, is that what we're talking about here? Is if I round off my income, I don't include the cents, that I've now violated 8.4C?
That is not accurate information. And the rule itself, 8.4C, does not have a mindset, negligence or otherwise, imbued in it. But all of our cases are considered on a case-by-case basis. And do
you have a case to cite to us where we have found a negligent act violates 8.4C?
I do not have one in front of me.
Okay, thank you.
Other questions?
If there are no other questions, I would simply request that this court find that Mr. Stewart committed multiple violations of 8.4C sufficient to find that his conduct was intentional, find that the aggravating factors outlined in the brief apply, and to adopt the Office of the Disciplinary Administrator's recommendation that he be indefinitely suspended. Thank you.
Mr. Ambrosio?
Madam Chief Justice, Your Honors, may it please the court. My brief covers everything that needs to be covered as far as the actual facts in this case. And a shout out to my summer law clerk, who's going to be our newest associate, Kinsey Bourdin, because I'm the worst writer in the history of the Western world, and my law clerks always wrote my briefs. Alcoholism in this case is what caused the problem for my client. He was drinking during this time when he filled out those applications, and during the time when he was receiving the money, from the time he got up in the morning until he passed out at night. Surely all of us know that that type of alcoholic use on a constant basis can lead to death. It can lead to mistakes. It can lead to infidelity. It can lead to all kinds of problems, including the problem that's visited upon us. I came into this case late, didn't represent them before the labor or anything else, only after the review panel found that there was probable cause to believe there was a violation and that it was set for hearing. And I looked at mitigation in this case is the most important thing, as are most of my cases before this court and panel's mitigation. And when I found out and listened to my client who told me that now, when he came to my office, John, I've been clean and sober since November 26th of 2022. It should be almost 800 days soon. I knew that that was the problem in this case, and that is what we hit on. He is involved in Alcoholics Anonymous. He is leading groups. He is involved with KLAP on a constant basis, hopes to work for them, and hopes to be able to continue practicing law. I believe that the panel listened to the mitigation evidence. I don't believe that they tried to create what the result was to be because they liked what he had to say, but because they thought he should be given a second chance.
That wouldn't be proper, would it?
Sure, it's proper.
It wouldn't be proper for a panel to base its finding on rules violations by considering mitigating evidence. That would not be proper.
Well, they found a rule violation, Your Honor.
Right, but maybe I misunderstood what you said.
You probably didn't. But I always feel like I'm in the musical Chicago when I'm up here, so.
It sounded like you said that the mitigating evidence is what drove the findings.
It may have. I'm sure they found a way to use that to drive the findings. They thought the mistakes that he made.
May I ask a question? Are you finished? I'm sorry. Is there clear and convincing evidence to support the panel's findings?
That it was negligence? I believe so.
That there was a misrepresentation that was negligent because how he reported his 3019 income.
Yes.
I mean, there are findings here. Are the findings that are contested supported by clear and convincing evidence? It's my understanding that your client is the only one that presented evidence in addition to the stipulations that were considered by the panel.
That's correct.
So the panel considered both the evidence from your client and the panel's stipulations and your stipulations as evidence and made findings of fact. Are those findings of fact, including the ones that are contested, well, specifically the ones that are contested, supported by clear and convincing evidence from the hearing?
I believe they are supported on the issue that they found, that there was misstatements due to negligence as opposed to fraud, which is suggested here.
Well, they found on the other ones that there was not clear and convincing evidence of a violation. So are those findings also supported by clear and convincing evidence?
I believe so. I believe so. And I think this was driven by mitigation. And I hear what you're saying. I think they listened to my client and believed what he said and believed because he was drunk all the time, dashed off these forms, didn't think about what he was doing, that he was negligent as opposed to involved in fraud.
Was there evidence that the forms were not particularly clear?
We talked about it. And the panel thought that they weren't clear because they discussed it in the panel report. I looked at the forms. I don't know what I would have done.
On that point, the forms just asked for income, right? Or was it?
They asked for income, but they also asked you to support with some documents also.
Right.
And if you read that report.
Can you answer my business association's question? This was a pass-through.
I was hoping you weren't going to ask me that. Just to say, I think it's a pass-through. I really do. And I think you're right about that.
If I remember from my BA1 class in law school, like any income, the income is treated, there's no distinction between the entity and the owner. The income is to the law firm is the income to the owner.
That's the way I remember it, and I went to school.
Was there any discussion of that in the?
No, there was not.
Okay.
But he did stipulate working during many of the weeks. He received benefits when he worked on weeks where he submitted forms saying he did not work.
That's correct.
And that happened on multiple occasions.
That is
And he
correct.
stipulates to it.
Yes.
Was that compensable work?
And that's where we get into.
Or was it
what
all
asked over here. That's where we
related
get
to
into
the
this.
contingent fee agreement?
He was working towards getting money under that judgment. And sooner or later, he hoped to receive money. On one occasion, he did. So he was working, but he wasn't getting paid for it. I want to get back to the mitigation, because the mitigation is the most important part in this case. And this is why this cries out for a public censure as opposed to anything else. He has done everything that he's needed to do to be clean and sober. And I know I'm up here month after month after month, arguing about alcoholism, depression, anxiety, drug abuse. And frankly, most of the people who are coming up here, if they aren't just plain thieves, and there are very few of those, have these problems when they carry them around on a constant basis. He is dealing with these issues and will deal with these issues for the rest of his life. And he's doing everything he can not to fall back again. And if you're reading the record, he was clean and sober for a long time. He dropped out of the church. And those of you who know me know I'm not very spiritual, but I admire the fact that he is spiritual, and that got him on the path to recovery. And his religion, his belief in a higher being, and his belief in the concepts of Al-Anon and Alcoholics Anonymous are what's making him live and what I think are saving him.
Can
But
I
he-
ask you a question about restitution?
The
same question. So was there some that he could have received under the PUA?
Yes, Shawn.
And he's paying that back also?
Yes. And as a matter of fact, by the way, last week, he paid the whole thing off. He worked his posterior off for 4 or 5 months, and he paid the entire $47,000 off last week. Because that was very important to him, but you're right about that. Without any further ado, I think it's important that my client address the court. I have your permission.
Just one quick question, kind of they're not nuances, kind of the legal questions that my colleagues have asked about business associations, how we classify income. Was any of that put before the hearing panel? Was that argued by either side or?
It really wasn't.
Okay.
It really wasn't. And
So
maybe-
this is the first time this kind of
I didn't think of-
questions have been asked.
I didn't think about it until Justice Daigle raised it.
No, I just want to understand
You're
that
right.
that was not, okay.
You're right. You're right.
That's all I want to understand. Thank you.
Yes, if there are no other questions of you. Yes, please, Mr. Stewart.
Madam Chief Justice, Justices of the Court, may it please the Court. My name is Shawn Stewart, and this has been an extraordinarily painful process, but one that was necessary. It was self-induced and self-inflicted. I'm thankful to God that He's a redeeming God, that He's a restoring God. And then He used an entire series of ill-advised choices and events in my life that really centered around my drinking to bring me to my knees and bring me back to Him. I'm so thankful to actually be standing here. I know it's a paradox. I've always dreamed of arguing in front of the Supreme Court, not in this case. But I'm thankful that I'm sober. As John's mentioned, I've been sober for nearly 800 days since November 26th of 2022. And it was on that day that I turned to my wife and I said, I have to stop this. I can't continue drinking. There were a series of things that were going on in my life. Everywhere I looked, I saw a rubble, I saw a ruin. And that was only from God. And so from that day forward, my wife and I have stopped drinking. And I've been battling this issue, this case, It was a week after I stopped drinking, thank God, that I received a letter from my wife. Opened up the mail. It was a letter about the complaint. And I'm thankful that I was sober when I got that letter. I had traded everything that I had loved and worked for, my family, for alcohol. It reigned and ruled my life. We talk about the statements of income. I guess I didn't care at the time. I stand before you today, a changed man. And it's because of what God has done and the people that He has used in my life to be here. Starting with my wife, who's here with me today. She's been with me since day one. She has stood by my side throughout this entire process. And I'm not a victim here. I'm not making excuses. I'm telling the truth. I'm stating what my life consisted of and what has happened to me and what I've gone through. And I'm thankful for John. John asked me about KLAP. I didn't even know who it was. I think maybe when I was in some CLE classes, I'd heard of KLAP and asked me if I was in AA. I had friends that were in AA. I had never reached out to them. So the first thing I did is drove to my friend Dan's business and told him about my story. And Dan said, we're going to Auburn tonight. We're going to Osage tomorrow to AA. And then John said, the first thing you're going to do is you're going to call KLAP. And I'm thankful for KLAP. I'm thankful for Bryn. What a tremendous asset KLAP and Bryn is to this court and to the community, to lawyers, those that are struggling with addiction, and those that don't know they are. Some of the best people in my life are the people I meet with every week at AA. God is doing some of His best work on this planet through people at AA. I've never seen more transformed lives in my life. And so I'm thankful for so many of my children. The level of support that I've received throughout this is indescribable from people in my house and people in my community. And I'm thankful. I'm very grateful for them. I'm grateful that God used all that I was going through for years to draw me back to Him and to restore me. And I'm thankful for the gift of sobriety. And I will stand from the mountaintops and shout to the world about how awesome it is to be sober. Since November 26th of 2022, as difficult as this process has been, my life has never been this good. My business has never been this good. I'm thankful for the clients that have entrusted me to represent their incredibly important causes through transactions and litigation, pending litigation I have. I'm thankful for the ongoing work, the trial that I have coming up in April. I'm just thankful. I'm grateful. Sure, I wish it didn't have to come to standing here today and to go through this. But as one of my dear friends in AA says, it takes what it takes. And in closing, yesterday, when I had asked people to submit letters in support of me, I didn't ask them what to say. I said, I'm facing very serious matter. And I read those letters, exhibits E through M. I read those yesterday, and I read words like integrity and honesty and character and accountability, and a man of God, a man that loves his family. A man who has admitted his wrongs, and a man who's sober. And as I read those letters, I recognize that guy. I recognize that Shawn Stewart. That was a person, and in those letters, they're written from people that I've only known for a year, for 2 years, and then all the way from 10 years to 15 years, 20 years, 25, and 35 years. And they all wrote the same thing, and I didn't ask them to. And I look in the mirror this morning and right now, and I recognize that person, and I'm thankful that that's who stands before you today. And I believe the panel got it right. I believe that the discipline of censure is appropriate. I'm asking and praying that would be the discipline. In AA, we have 12 steps. I've went through those 12 steps in this case, literally. And one of those is to make amends with all those that you have wronged. I don't know how I could do anything more than what I've done to make amends in this case. As John mentioned, I paid all of the sums, some of which I was entitled to. I've paid all of every dollar back to the state of Kansas. I've admitted my wrongs. I've apologized. As I go forward every day, I think right, I try to do right, and I pray right. And I'm thankful that God's a God of a million second chances, and I'm asking that this court would give me a second chance, that my license would not be suspended, that there would be a censure, and that I would continue to be able to do what I thoroughly love. One of the most in my life is to practice law and to continue to represent my clients and to be a testament and an example to others that are struggling with this addiction, that there is hope, there's help, and that God's not through with them. I truly thank you for your time. I thank you for your service to the state of Kansas.
Thank you for letting him go over. That's part of his recovery. Thank you.
I want to address a handful of things that this court asked Mr. Ambrosio. I would note that to the question, Justice Rosen, about the first time things came up, because of the stipulation, there was not evidence or discussion until the hearing panel asked about the exact mechanism of how money came into Mr. Stewart's law firm about any of that. In the stipulation, Mr. Stewart admitted he received income on weeks that he said he did not. And he admitted to that at the hearing as well. There is a point, for instance, on page 57 of the transcript where he said there were weeks that I didn't work and didn't receive income, and there were weeks that I worked but didn't receive income, and there were weeks that I worked and received income. The same is true with the working. Mr. Stewart stipulated to and testified he completed work at times but said he did not. In terms of the forms and their clarity, the evidence in the record about forms being unclear is really about one form, that is Exhibit 7. It is the PUA application. Some of the check boxes, it was hard on the copy that is in the record to tell what was checked on there. However, when it comes to overall the clarity of the forms, there's no evidence either within the stipulation or within the testimony about those forms, to my recollection. I would just point out that, sorry, I can't read my own handwriting in this moment. I would point out that the amount Mr. Stewart repaid, Justice Wilson, that is through, he set that up through the Department of Labor, that is within Department of Labor's policies. That is not something our office, set that number or anything like that, just for the sake of the record. And I would note some of the evidence in the stipulation, additionally, including Mr. Stewart's statement that he was initially concerned about his law firm weathering the storm, but eventually was also trying to create a financial safety net for his family through this. Justice Stiegel, I have been thinking about your question about rounding income. I will admit, when you said rounding income, I was imagining rounding up 82 to 90 or something like that. The preamble of the rules talks about them being rules of reason. And I also think it is important to note the preamble discusses, and our case law discusses, that lawyers are held to the rules even in conduct that is not directly related to their practice of law. And when we have here a situation where it is not rounding up 49 cents, but large amount, repeated instances of providing false information, and to an extent that results in a finding by the Department of Labor of fraud, that is a distinguishable situation. So unless the court has any other questions for me, I would thank you for your time this morning.
Thank you. Thank you to everyone for your statements and your arguments today. We'll take this matter under advisement.